That sounds good.
Great. Well, thanks everyone. Welcome to this special webinar presentation brought to you by the Alliance, but completely conducted by Charles Thomas from KPPB, a great asset to the entire ecosystem here in Southern California, and especially in the life sciences area here where Charles operates. And I'm just going to briefly introduce Charles and let him take over, but I want to say for housekeeping notes, Charles is going to basically present for about 30 minutes or so. And during that time, he'd love to take questions if they come up. So please either raise your hand using the hand raise feature on your Zoom, or feel free to type in a question to the chat, and we can ensure that Charles will see it and I can call it out too. Then after his 30-minute presentation, we'll have plenty of time for also more Q&A questions, and feel free to bring up your specific examples or questions about what was on the presentation. And this is supposed to be kind of an interactive workshop, so please treat it as such. This is for everybody to learn. And so with that, I will introduce Charles. So Charles, as some of you might have read in his bio, if you found it on the website, or on the registration page. But Charles has got a very unique set of experiences here that make him uniquely qualified for this presentation. Not only does he have, I don't know, 3 undergraduate degrees in biochemistry or chemistry and biology, and as well as a doctorate from UCSD in biochemistry, and then also it was a JD from from USC. So he's worked in academia, he's worked in the private sector, working on biotech, and so he comes to us with just a great variety of experiences, and has worked in IP for, is it about how long, Charles, has it been working in?
Just over a decade working at my firm, yeah.
Yeah, fantastic. So yeah, a lot of experience here, and of course, Charles works for a law firm, KPPB, which does IP for across a range of different technologies, including technology, everything from deep tech to life science. So a great firm. We appreciate their leaning into the ecosystem and helping out startups and founders wherever possible. So with that, I will leave it to Charles to take over, and I'll be here in the background moderating. And but if you get anyone who has questions, raise your hand using the interactive feature. Don't just raise your hand, your camera. We might not see you, but do or put it in the chat, and we'll be sure to check in with you. So Charles, it's all yours.
All right, excellent. Thank you. Thank you so much, Steve. And thank you to the Alliance for giving me this opportunity to present to you guys. Yeah, so, well, before I begin, one thing I do have to say to meet my ethical requirements is that this is not legal advice in the form of a, attorney-client. We would need to engage into a role. So, so this is just kind of for your viewing and for you to kind of take in, but it doesn't establish that sort of relationship. And that's just required by ethics that I say something like that. But let's get into it. I do thank you, Steve, for that background. Let's see. Will the slide move? There it goes. Okay. So yeah, so as he was saying, we are a firm based in Southern California. We actually span KPPB. We span across California. I'm actually personally based in San Diego, but we have attorneys in LA, all throughout LA County and Orange County. We have our central office is in Long Beach, because that's somewhat centralized to kind of the bulk of our attorneys. But we do kind of have little satellite offices around as well. And as I was saying, or Steve asked, yeah, I've been working in specifically within, as a patent lawyer or a patent agent for the past decade here with KPPB. The tasks I typically perform are I can do pretty much anything related to patent related IP, but my main tasks that I kind of perform are patent drafting and getting the patents through the office. We call that patent prosecution, both at the USPTO, and I work with foreign attorneys to help get it through, for instance, the European Patent Office and other patent offices throughout the world and other countries. Other tasks are due diligence, freedom to operate, prior art searches. These are kind of typical tasks that go along with, assessing patents. I also do some litigation support for any sort of um litigation that's ongoing, that's either related to something I've prepared or within the life sciences, and they're kind of wanting a patent attorney's perspective from that side. As I mentioned, I do focus on the life sciences, medical devices. I do quite a bit of bioinformatics and AI applications. I would say, with the kind of the boom and the expansion of computation, especially within biology, computation and artificial intelligence, that it's definitely become a key focal point of my practice is um, on AI. And my education background is based here in Southern California. So I've been in Southern California for quite a bit now, since 2008 when I started up at UCSD. So I am kind of a Southern Californian now. I grew up on the East Coast in the DC. I worked at a biotech right outside of Bethesda, um, for a couple of years before enrolling at UCSD. So the outline for what we'll talk about today are the types of intellectual property. We'll also talk about determining what to protect, how to protect it, and when to establish protection. And then within that kind of topic, choosing between patents and trade secrets, startup scenarios, and pitfalls and mistakes, and how to avoid them. Uh, in this first part, I don't know everyone's background with intellectual property. I imagine some people have more experience, and some people are probably novices to intellectual property. So please bear with me if you are a little bit more experienced. So kind kind of the four main types of intellectual property, especially as it pertains to companies and including startup companies, are patents. This other concept of trade secrets, and kind of the more broadly, something that is referred to as know-how, trademarks, and copyright. I'll talk a little bit more about patents and trademarks on the next few slides, but regarding trademarks, these are essentially what establish brand recognition. 'Cause some famous trademarks related to life sciences and academics down here in Southern California include Illumina, Alliance for SoCal Innovation, Amgen, UCSD, USC, the schools that I went to um, for my education. And so the companies use these to protect their their brand and to protect their products. The real purpose of and most people actually don't recognize this. The real purpose of branding is to prevent customer confusion. So when a consumer buys a product, they know what they're getting when they see the brand. The brand has a certain reputation, and with that reputation, you know what you're getting in your product, and that's why it's trademarks, right? You can't have knockoffs or things like that. That's very heavily criminalized and prosecuted, because we don't want to create this confusion. And the most times when trademarks are not allowed is because they would be confusing with another trademark that either already exists or it's too generic that it doesn't necessarily signify a company in itself. And the only other thing I'll talk about copyrights is this. In turn, for life science companies, this really relates to mostly what computer code people are developing for, um, either IA and or AI, AI, and other sort of analytics that they're being done. So you can protect it in computer code by copyright, but an important thing that I will not get into much further within this talk is copyleft obligations. Anytime you build upon prior code, you have to recognize whether there's copyleft, and it may potentially affect how you can protect it or whether you can actually get a copyright on it, or even it can even affect your pursuing patents and um and well, trade secrets are fine, but it can affect whether or not you can get a patent sometimes. You can so some things you can protect are right website pamphlets other than computer code or product description, longer phrase, things that you might want under your brand name. Um, these are things that it can be protected by copyright. So there's some value in getting these as well. Um, Uh, so to kind of go what the patents are and kind of different, and we'll also talk about trade secrets in a second. But a patent protects novel and inventive technologies by granting an exclusive right to exclude others from practicing the invention. It doesn't give you the right to practice it. It gives you the right to exclude others, and that's a pretty important concept that uh, we'll talk about others or a little bit further down as well. Especially when we talk about some licensing university technology. Um, and so what a patent does when you get it granted, it protects your invention. If someone else ends up practicing your invention, like they start doing what your invention covers, you have the right to sue them for infringing on your patent and stop them from doing it, or uh, get royalties from them if depending on there are different outcomes that can come out of a litigation for a patent. So the patent components, there's three main components. The description, these are the words that describe it, the figures that kind of, portray it, and the claims. The claims are what define the invention, and they must be fully based on the description and figures. But they are modular as you go through the prosecution process. And what is that patenting process? Well, first we put together a provisional patent. You actually can skip this stage, but in practice, it's almost always we file a provisional patent application, and that will establish your priority date, establish kind of when the invention has been invented. Within a year from that first priority date, we must file the non-provisional patent application, and this is what actually gets reviewed by the patent offices, whether that's the USPTO or other, right, the European Patent Office and other kind of worldwide patent offices. Um, so that's the patenting process. And while we're going in review this patent prosecution, we can't change the description and the figures, but we can update our claims. And that's kind of the process, is to get the claims adjusted such like the patent offices will say, oh, this is not novel over this or this prior patent or this prior publication from Nature or something like that, and then we'll have to work around it using what our description and figures provide. Some specifics about the U.S. Patent and Trademark Office, because this is kind of some recent developments. We have Acting Director Coke Morgan Stewart. She was just brought on in January, and this patent here on the left has her signature. It always has the director's signature at the bottom when the patent is granted. But she will soon be replaced by the nominated director. It is presumed that he'll be able to get through the Senate. I actually think they talk about him on Friday of this week, but it will be pretty soon. We'll talk about him. And the only reason I bring this up is that if you are familiar at all with the issues around patenting AI inventions and computational inventions, well, the new patent directors that have been put in place are very pro AI, very pro computation, and very pro patent, which means there's a good likelihood that to a certain degree within the degrees of freedom they have from what the court cases already have established, they'll probably push for a more patent granting um, position, but they'll also advocate within Congress to get patents to get the patent laws changed, and Senator Coons and is one of them. But there's already legislation that's been drafted looking to make these changes. Yeah, so they're very pro patent and pro AI. So what is know-how and trade secrets? Know-how is really kind of what you know from knowledge, your experience, your strategy, and there's really two types of know-how. This is both institutional and personal, and they're not mutually exclusive. What you know may also be institutional. I mean, especially if it's passed down, right, from a coworker or your boss or someone that trained you at the company. And one of the good examples I like to give during my graduate years, I did a lot of stem cell culture. I did a lot of protocols where we were taking stem cells and generating neurons and assessing them to I was looking at a neuroinflammatory disease called Aicardi-Gouttier syndrome, and so we were modeling it using a cell system. So, right, so our lab had written protocols, right, and these are definitely be somewhat kind of institutional know-how. I mean, I guess you can also write your own personal protocols, but as anyone knows that has done cell culture before, you kind of know how to optimize that protocol in your head, right? Every time before you do something in cell culture, you will look at the cells and kind of make an assessment of what I should do here, or whether or not to take the next step, or whether to just toss these cells because they've already differentiated into something that I didn't care about. So that's definitely very personal know-how, and generally not as institutional, but there are ways to kind of make it institutional. And it's an important concept that there's no formal method to legally protect know-how generally. And anybody can take their personal know-how with them when they leave a company. But there is a legally protected form of institutional know-how, and these are trade secrets. And a know-how becomes a trade secret when there's a formality attached to the know-how and remains secret within the company. It can't be publicly disclosed. There is possibility that you can have a collaborator or an industry partner and work under an NDA, but that's possible. But when someone leaves, if it's a trade secret, they can't use that trade secret at another company. And even in, but the important thing is, if it does become public, even by a bad act, it ends the legal protection of a trade secret because now it's public knowledge. It's no longer a trade secret. But even if it's a bad act, or someone leaving your company and misappropriating the trade secret, you can pursue criminal or civil action. So there is a lot of protection around them. So when do you choose a patent and when do you choose a trade secret? So trade secrets are really ideal for fully internal processes, reagents, and data that will never be public facing or otherwise made available to the public. Um, you one thing that's important is consider whether it's advisable to share trade secrets under an NDA, right? Like you have no control of another company. Perhaps they will publicly disclose it. Perhaps they will do, maybe they'll file their own patent on it. While that may break the NDA, and it may also break laws, there is you got to be really careful of sharing that. Examples or your protocols, your data results, your computational algorithms for internal processes and assessments. So yeah, these are some pretty key examples. And with these, you want to formalize these protocols and these data results and et cetera as a trade secret. And there is a process to do that, and it's kind of an important process. There is when a court will look at whether something is a trade secret or just know-how, there are some key factors that kind of make that determination, and so it's important to work with an attorney to get that established. Patents are a deal for anything public facing, especially, right? You're going to present it. You're going to, it's going to be within an FDA regulatory filing. If it's important things to consider is whether it can be reverse engineered. If it can be reverse engineered, you probably want to patent it. Also the other thing you want to consider, are there similar other companies or institutions, academics that are kind of working on similar things? Will they come up with it on their own? Maybe they'll file a patent ahead of you if you try and keep it as a trade secret. So it is important that you do kind of make these kind of decisions. But some right, like anything that you turn into a therapeutic, vaccine, medical device, diagnostic methods, reagents that are public facing, you'll definitely want to get a patent on. So we're going to take the last 10 minutes to kind of go through a series of examples of startup companies and their IP portfolio status. As we go through them, definitely see if any of these scenarios are familiar, and then we'll troubleshoot mistakes that are made by these startup companies. After we go through the scenarios, we'll just further discuss some common pitfalls and mistakes and how to prevent and correct them. So scenario one, this is when there is no core focus to their IP, or they have no IP and there's no core focus to they're this kind of like a company trying to exist and get money. But so right, an early startup company is looking to acquire funding. They inquire with investors, and upon being rejected by all the investors for having no IP and no strategy for generating IP, they will reach out to an attorney like me and request to file a patent on their technology, but they don't really have like real good technology that they're really kind of developing. They just describe it very generically and it's unformulated. They don't, and they don't really care what the patent covers. They just want to get it on file to show potential investors, and things like that. This is common. I've only seen this with a biotech company maybe once or twice. This is more common for like app developing, companies that, oh, I have this next generation app that'll be good. I've seen this with veterinary companies too, but hopefully this is not the status you're in. Hopefully you are at least looking to generate IP that is there. So the major issues here are investors want to know that you have a path to market, right? So you need to have a market share that is exclusively yours, and IP protection is the best way to establish exclusive protection. Patents by excluding others from practicing it, trade secrets such that nobody else knows what you know. And so that's really important to kind of develop your IP, and this should really be tied with your business plan. So if you don't have a core focus on your technology or a core focus on your business plan, it'll be very difficult to get meaningful IP because you're not really what are you generating the IP for, and like what is your market strategy to get to create a successful company, and how do you get there? Right, you really need to kind of have that kind of core business feature. often centralized around the type of technology that you're trying to enter the market with, and it's very important to protect that technology by both patents and trade secrets. And so investors really want to see these focused business objectives, like you're going to do X, Y, Z by year one, by year two, um, and how soon you can get these products onto trials, into clinical trials or onto the market. And it's really important that you tie your IP strategy so you don't lose the ability to have your corner of the market. And so the next scenario is a pretty common scenario. And so in this scenario, a company only has university licensed IP, right? So an early startup company is looking to acquire funding, they inquire with their investors. Uh, they de- they detail their technology. They have like a good slideshow, which is based on a research project carried out by the founders at an academic institution, or sometimes people actually find something in an academic institution that's not affiliated with them and license it there. But despite having exciting data and well formulated business objectives, the investors decline investing in this company. And why is that? Why do investors not want to invest in a company that only has university licensed IP? And so, what are the issues? Well, the key issue is that, right, as a first point of note, that I do want to get out there that university developed IP is a great way to get a company jump started, right? Especially if you were involved um, in doing that university work, right? You're clearly an expert on that technology, and you're using that as a platform to get your company started. But a key thing is that the company doesn't actually own that IP, and even if it's an exclusive license, the university really controls how that IP is developed. They might give you a lot of liberties on how that's developed and things of that sort. But they can always pull it away from you, especially, right, like you have a conflict with the universities. Maybe there's some financial issues that arise, and like you're unable to make it, or maybe you're not meeting the milestones that are required by the university, right? And so they can just pull that IP back away from you, and then you're left with no IP. So it is really important to establish your own company IP. And this is something I actually see quite a bit when companies come talk to me, startup companies for the first time. Most of the time, they're looking to develop their own IP, which is great, right? They're starting to build out their own company IP. And so when I talk to them, I always to them about the ability to freedom to operate underneath the university IP, right? So I because there's a right to exclude. If the university owns the IP, um, they can, in theory, exclude you from practicing it. That's why you have to get the license. So it's ideal that not every further patent that you develop, or IP that is developed, is solely subjugated to that first patent and the license agreement, because you're right, like you just don't have as much control over that. So um, yeah, you really want to get that IP that's your own company's IP, and if it can be uh, operated without requiring the license from the university, that's good. I'm not saying that everything your product will have to be 100% free from the license, but just having some IP that is free to operate from that is really good. And I mean, it just greatly enhances your company valuation, and that's going to be really important to investors. Also, when exiting, also if you move into like an IPO stage, something like that, it's really good. And so I'm going to talk a little bit about the scenarios that are a little bit further downstream, kind of something to look at. And the first is, right, a company that already has Series A funding, and they're looking for their Series Bs. And this is a company with an unfocused IP strategy. They but they really prepared a great slide deck and have a good strategized business plan, and they show that, oh, that we have 15 patent applications, so we really have a lot of IP, so we're worth a lot of money. We should be valued really high. And the VCs agree, and they're like, okay, we're gonna reward you $20, but we're gonna subject that award to the due diligence that we're going to have our attorneys perform. And when the VC's attorneys discovered that they had 15 active patent families, but only two relate to their exciting data and the strategized business plan, and they further see that the unrelated patent families are filed in over 10 countries worldwide, and it's just kind of hugely expansive on their IP. The VCs will back out of that because what they see what are the issues here? What the VCs are seeing is that although they have the expansive portfolio, it doesn't really align with their business strategy, and the expand it's actually can be a hindrance, right? Because one, it shows the company may not know how to focus effectively and get to the market, and two, um, you really can potentially be wasting a whole lot of funds that the VC doesn't want you to waste if you're, really going like, why are we getting a patent in in Brazil for something that we don't ever plan to use, right? Like, why are we doing that? Um, and so they'll find anything that's like unrelated to your core strategy or what's really going to make your company have value and get to the market, they'll find those patents will have less value. But there are exceptions, right? Like if you have IP that's going to be becoming like your second core product, uh, there are strategic patents to limit competitors in the market, right? Like this may not be within your core, but it could be used by a competitor, so you prevent the competitor from using that. It kind of expands your market in that way. Or sometimes you have, a really good patent that has high inherent value, right? I've seen cases where industry partners are really interested in the patent, and so they may even help pay for it or give royalties in a licensing situation, something like that. But the other issues is not formulating the company's know-how into trade secrets. The company is at risk of losing this proprietary, and the other issue is that all all employees, including founders, really need to sign an employment contract that includes the language to the effect employee hereby has assigned their IP rights to company, which establishes that the company has their IP that is developed. And this last scenario, which I'll jump through pretty quickly here, is right. So we have a company, and they've done a really good job of aligning their IP with their business strategy, and they present it to the venture capitalists. Their venture capitalists are very active, happy that they're during due diligence. It's discovered they have one active university licensed patent application and three active company-owned patent applications, but these three applications are improvements to the university technology. Um, the employees all have signed, every single employee has signed an employment contract that states employee will be obligated to assign any IP developed in the course of employment. And they have labeled their protocols as trade secrets, right? So this sounds like they're doing really well, and in fact they are doing really well. But there are a few issues that I'll point out really quickly. Their portfolio is well strategized. It is clear that they've tied it and aligned it to their business um, uh, objectives, and but the issue is they all their own company-owned IP is subjugated to the university's IP because they're only improvements to it. I mean, there could potentially be freedom to operate from underneath of it, but you really do want to, right, like have your own strong IP. The labeling of it, right? There's several factors on what determines what is a trade secret. The mere labeling of a protocol may or may not um, hit may not determine it. There's really a lot of other things that can be done to really strengthen that protocol as a trade secret. But I'll note having the word trade secret on a protocol will definitely help establish that as a as a trade secret of the company. And the employee contract. This is something that's tricky and something that's hopefully any startup attorney that you work with that does the business side of things with the employee contracts and things like that. They don't have this specific language, but it was common to have the language will be obligated to assign, and this happened at certain universities, including the guy that invented PCR at Stanford, and he was working with another company, but the long and short of that is the company uh, had him assign rights to that company, and what happened was Stanford actually lost the rights to that IP because the statement was will be obligated to assign, meaning he hasn't yet assigned it, but he'll be obligated to it. But then he had signed a second assignment to the company, and right, the Stanford lost right to that IP, and that's can be a concern here. You could lose employee developed IP if we don't have the correct language in there. And so the last couple of slides I'm going to get through pretty quickly here are some mistakes and how to avoid them. One common mistake is failing to protect core technology. And we really just need to be mindful of our business objectives when developing IP, and we should consider how to protect it. What's important to get to be competitive within the market, and definitely should work with a patent lawyer to go over your business plan and your technology. Make sure we're aligning things. Make sure we're determining what should be within a patent or what should be within a trade secret or within a trade secret for X amount of time and then filed into a patent sort of thing. So we really want to build that picket fence around our technology and protect it. So too little IP or too much IP, this is really just being mindful of both our business objectives and our financial constraints, and the cost benefit of where we file, how much we file, and what is filed. Do we file everything that we have developed? Is it will it be important to the product that goes on there, or is it just kind of something we found out? Would it have value anyways, right? Like so there's all these determinations that we need to make sure we hit that Goldilocks amount of IP, because right, survivability is the name of the game in startups, and being survived until you can get that next round of funding. And definitely work with a patent attorney to determine the right amount of IP. And another mistake is the one I just talked about, that having the hereby assigned, or failing to establish trade secrets from know-how. Just make sure you have all your onboarding protocols, methods in place. Make sure you have everyone signing their employee agreements, including founders, and be sure to establish your trade secret policy. And that's kind of something a lot of startups don't think about, is trade secret policy, but it is kind of an important thing to kind of deal with, to make sure that people, including founders, right, like they leave, maybe they want to take what they're to another company, because they end up having a disagreement with the other founders. So you do want to get these sort of things assigned to the company, such that they can't walk away, and working with patent lawyer to set up your policies and your protocols is very important. And this last slide, and this is the last slide, is hiring IP attorneys that essentially don't do a good job of what you need as a startup company. And I see this actually quite a bit. I work with a lot of both academic institutions and startup companies, so a lot of times I'm on either side of the licensing agreement, whether I'm working with the startup that has licensed university technology or working with the university that has attorneys working with the startup company. And you really it's really important to assess the IP of firms and attorneys that when hiring and as you continue to work with them, right? Like it's important to do it not just at the moment you hire, but also as it's going along, making sure that they are kind of like, does it seem like they're meeting your business objectives? Are they helping? Are they hindering? What you want to look for in your IP attorneys, right? They should have experience with startups. There are so many IP attorneys that work for only big companies, right? They work for Samsung, Apple, et cetera, and they won't really have the experience to really help navigate, the complexities and the issues associated with startup companies. Another issue I see a lot is uh, being able to speak your technical language and understand your technology. I see, and this is especially in I noted that I've done a lot of kind of computational and AI um, patents, and sometimes I'll see attorneys of licensee companies, and like it's clear that they don't even know, like they can't understand the claims or that patent application, but they're hired because they're reputable, experienced attorneys within the life sciences field. But yeah, they're not doing their clients a good service. Um, and you do want to find firms with predictable and navigable fees, right? Like you want to have an expectation of what you're going to pay when you have a patent application prepared, when you're going to go through prosecution, and just kind of as certain tasks or do it. One great way to do that is work with a firm that uses a flat fee schedule. For instance, KPPB, over probably 95% of the work we do within for a startup company will be on a flat fee schedule. So we can really project out, and you can look and kind of figure out what the cost will be in order to do, for instance, prepare a patent application. All right, respond to this office action. What will be my cost within the next year? Well, we can predict how many office actions will come in and the cost to respond and things like that. So there's definitely a lot of advantage working with firms that use a flat fee schedule for patent development and prosecution. And what to avoid? Um, there are and there's actually very popular firms that kind of do a lot of these different things, maybe in different formats. So firms looking to take equity, your equity, there's two issues with that. One, your equity value now is not nearly what it's going to be if you're successful. So the firms will be looking to take your equity, and right, it's like they're the value that they provide as services will never meet the equity value if you're successful. But I understand sometimes you're short on it. The second thing is when you actually go to investors, right? They're not going to. They don't want to see that you have on your balance sheet that some of your equity is with a firm that kind of like maybe uh, kind of the investors don't like to see that. There's hindrances to it. Maybe the investors kind of want you to work, go in a different direction or something like that, and having a law firm on there just kind of maybe stalemate some of that. Also be cautious of starter packages. I think this is pretty common for startups that the law firm will offer a starter package that has an initial amount of attorney services included. It sounds really nice, and it sounds like you're going to get a ton of attorney services, but it's usually blown through really fast. And then you're working on an hourly rate with a high-end attorney, some partner or something like that, and like your bills go way up, so pretty quickly. So there is definitely a lot of advantage to working with something that's more consistent throughout, and what you can expect throughout the tenure of your relationship with your attorney. And I see this quite a bit. Um, Firms charging for unnecessary items. They're always taking some sort of action on every single office action. They're always doing things that aren't required with the USPTO or certain things, and they're just right. They're just having you do this because it's right another way for the firm to make a little bit more money on it. So definitely try and be cautious of that. I know it's hard to kind of predict, but if you definitely feel it, it's probably happening. And with that, thank you. I appreciate everyone that's listening. On the top right there, that's my dog Onika. She's a little fluffy Frenchie, and that's me after hiking up to Mount Baldy up there in LA County. So I'll definitely take any questions that people have, and I can definitely be help with questions afterwards as well if you want to contact me directly. And yeah, so thank you so much for joining us.
Great. So does anyone from the audience have any questions for Charles?
Oh, I see there's something in the chat. Oh,
Well,
that's
I put your email in there just for everyone who, in case they want to
perfect.
copy and paste it.
Oh, we went the wrong way.
Any questions? Anyone have any situations that seem familiar or specific situations, maybe like Charles to
Yeah,
provide some
I mean, if it's particular or less particular, broad, general, I can help answer various questions that you may have. I'll just note, just don't be too divulging, right? Like, if there's something that would be considered proprietary, that that would not be great. It's good to share publicly at the moment. So, um,
Charles, do you often take on clients in negotiations with the university?
yeah, we do that as well. Generally, um, these are these agreements are pretty straightforward,
Mm,
and so there's not a whole lot of negotiation
mm,
to occur.
right.
At least from a startup perspective, maybe if you were a big company and offering to pay a lot more.
Mm,
But yeah, we do negotiate with on the behalf of startups and
gotcha.
with universities. There may be, and if we represent the university, there may be a need to get a conflict waiver,
Mm,
or something of that sort in order to do it. But we do.
yeah. Looks like Melanie has a question.
Yeah, hi. Thank you. That was really interesting. So I have a question. If a technology is developed in an academic setting, um, frequently the university will actually contract out with a law firm to file the patent.
Yep.
And then if you have a startup, do you want to use that same lawyer? Is there a problem with using the same lawyer, or?
Yeah, so this is like I've said, I've been on both sides of the coin of these relationships. I will say it ultimately depends on right the financial situation of the company, and it will also depend on your license agreement to a certain extent. But in order to have your interests right, so that attorney will not be able to represent you as a startup company. They will not be your client. But so I tell like I have this situation where I do university work and there is a startup company and I'm doing all the work and they don't have their own attorney. So even when they contact me and they have these specific questions, sometimes I have to be like, "Hey, I can't answer that. I'm not your attorney. You can refer," and like I'll always have to like CC the university OTL or Office of Technology or whatever they call their office. And make sure that that there is like that I because I represent the university and not that company, make sure that that relationship is maintained and not broken. Um, so the thing that's so it is definitely always better if you can afford it and right and like you're always allowed to get your own attorney. They can't restrict it, but there may be situations. Oh, so for instance, a lot of times licensees will have their own right the company that's licensing out the technology. They'll have their own attorneys, and those attorneys will actually fully dictate how the prosecution goes. And that is an ideal situation for university licensed IP, because that company has an exclusive license and they're determining how it gets put together, and they're always paying full, for all the prosecution to be done, but they're doing what is best for their company as determined, by that IP attorney. So yeah, it's definitely that's the ideal scenario, to have your own IP attorney, but I know not always available, depending on financial restraints. And all right, if you're looking for funding, that's something VCs are going to notice too, right? They're gonna, so who's your company? Who are your lawyers and things like that, and you won't be able to use the university lawyers to even negotiate the VC contract or any other sort of funding contract, angel investors, etc. So definitely
So Charles,
important.
So just clarify, just make sure I heard you correctly. So you're saying if you representing UC Irvine on the patent protection or the licensing agreement on behalf of that technology and the IP in the portfolio, and then that the PI then wants to take that licensing, create a startup, and they want to then create another patent, say a subjugated one, you're saying that you would not be able to represent the startup because you had already worked on the licensing part of it. Is that what you're saying?
So not exactly what I'm saying. So that can be true. There's going to be, right, if I represent the university may not want me to work with the licensee, right? They don't want me on both sides of that relationship. There's some times when it's fairly aligned, and you can get a waiver with the university in order to work with that startup company. What I was specifically saying is a certain piece of licensed technology is going to go through prosecution, and if they have their own attorney, that attorney and the licensing agreement allows for this, that the attorney of the licensee can dictate the entire process. And as university attorneys on my side, as a representative of the university on my side, what I do is I get their product, make sure everything looks fine. I do kind of like edit it and kind of maybe provide suggestions sometimes when appropriate. But generally, I look at it, make sure the university interests are not hurt by the response or whatever it is, and then put it on file. The university's attorneys will all right, because they own it, so they're the applicants and they're the one that's moving it forward. But the whole kind of strategy and development of it is really done by the licensees council.
Thank you. That's super helpful. Thank you.
Of course.
Great. Other questions? We probably have time for one more question. We're right about time, although I'm sure we can run a few minutes late if that question requires a longer answer. All right. Well, you have Charles' information in the chat if you want to follow with him directly, and which I recommend you do. And then otherwise, thank you all. And Charles, thank you so much for this presentation. It was really enlightening. Hope the audience got a lot out of it. I know I sure did.
Yeah, thank you all for listening. Yeah, I can definitely reach out if you need a little resource. I can answer some questions within limitations, of course, considering my ethics requirements and things like that. But I would be happy to take a further conversation if that would be of help. So please do reach out.
Great. With that, I will wrap it up. Thank you, everyone, and have the rest. Enjoy the rest of your day. Take care, everyone.
Thank you. All right.
Thanks, Charles.
Bye.